I'm glad you can join me today. I want to talk about how our law firm can win a criminal harassment trial. You'll see in other videos, I have a video on how to drop these type of charges, and how to go about getting withdrawn. So this is not to be confused with trial. This is a situation now where the Crown has refused to drop the charges and the matter's heading to trial, okay? So what strategies do I take, or the lawyers at our firm, or any lawyer for that matter's experience, to win that type of case? So first of all, it starts really with the original disclosure. When a client hires us, we order all of the police reports, the witness statements, the videos, you name it. All of the evidence the police gathered is given to the Crown Attorney, and they have to give us all that documentation, whatever that is, and it can consist of literally, dozens and dozens of pages, up to thousands in certain harassment cases. So once I have that, once the lawyers have that from our firm, I sit down and I review it all. Now that may take me a day, it may take me multiple days, it really depends on the length of the disclosure. And I'm asking myself many questions. I'm asking myself, what are the strengths and weaknesses of the Crown's case? Do I think the Crown can prove the elements of criminal harassment? Is this a winning case? Is this a losing case? What are the odds of winning or losing? So ultimately, if we're heading to trial, normally it's a type of case where we think at least we have a realistic chance of winning. Based on the evidence I see in the case. So I'm going to meet with the client after I've finalized my opinion at that point. And I'm going to review everything with the client, go over all the case with them, review the disclosure with them generally. I'm going to receive their version of events as well, a verbal version at that point in the office. It might be a couple-hour meeting, might be even longer if it's a more complex case. And it's the first of many meetings. If this is heading to trial, my God, there's so many meetings we're going to have in preparation. It's endless. There's going to be dozens and sometimes hundreds of hours of work involved in some harassment cases. So I then say to the client, if it's an overwhelming case against them, I tell them, we can't win this case. We need to, resolve it and get the best deal we can, get the latest sense. But I'm talking about a case that's winnable. I've looked at the case. I'm thinking, well, you know what? Has the Crown really proven the elements of criminal harassment? Did the complainant really have reasonable fear? Not every situation where a person receives a few emails that, and unwanted phone calls does the person have fear. I've been in cases involved where, a 30-year-old man was claiming he was fearful of a 70-year-old, 80-year-old woman for sending him a few emails. I mean, it's not reasonable. I'm just giving you an example of what's not reasonable fear. So you have to ask yourself, based on the allegations that the person's making, would a reasonable person, the reasonable objective person out there in the particular circumstances of this complainant, have that fear? If the answer is no, the Crown can't prove their case. And that happens often, believe me. But there are obviously cases where, stalking and ongoing persistent emails where you've asked them to stop and phone calls, at some point the fear becomes reasonable, there's no question. So the client writes out their version of events. I've told the client, look, I think we have a reasonable chance of winning here. Part of it is based on, there's documentation, there's emails. I don't think they crossed the line. Part of it's based on what this witness is saying. They've given a statement that I think we can challenge as not being credible or reliable. And the client says, okay, off to trial we go. So when I have the client come in later, review that disclosure by themselves, write out their version of events. We go through multiple drafts of that to hone that. I refresh their memory. We need to get it in a format that's court-friendly, if I might put it that way, the way I want them to testify in court. Their words, the truth, of course. They're saying they didn't do it. And that document, their statement, coupled with the disclosure, is my roadmap, if you will, for challenging and trying to win this case at trial. In the real hard work, there's a lot of upfront hard work to get ready at this point, but the real tons of hours go in the month leading up to the trial. I'm going to be meeting with the client multiple times to go over and prepare their version of events because they may need to testify. I need to go through mock examinations, mock cross-examinations where I prepare them as a Crown to make sure that they're going to be a good witness. Because even if you're telling the truth, you just don't get up on the witness stand and do a good job. Truthful witnesses sometimes come across as complete liars because they break down, they can't keep their story straight. So it's important to properly prepare the witness and correct things that they're saying wrong that the judge is not going to like. They need to say a version of events a certain way. They need to know the questions the Crown Attorney is going to ask them so that they can pair answers that are proper. Again, don't think a criminal trial is ever search for the truth. I've seen very truthful witnesses get destroyed, absolutely destroyed by clever lawyers, unfortunately. And some people are very good liars. It's a sad reality. Winning a trial is about hard preparation, and part of that is getting your client ready to testify in a manner where they have a chance of winning. Now, at the trial, my strategies to try and win these type of cases are, number one, to show that the elements of criminal harassment have not been met. It wasn't really repeated stalking. The phone calls were innocuous. There was no fear. It's just exaggerated. They're saying there was other following that can't be proven. I'm looking to challenge that witness to show there was improbabilities, inconsistencies. If I try to create inconsistencies between their video statement and what they said on the witness stand and show that the judge, they can't keep their story straight. All with a view to creating a reasonable doubt. Now, that reasonable doubt can be created in many ways. Number one, they could be the most credible and reliable witness in the world, but if the emails don't reach the level of harassment, sending 5 or 10 unwanted emails is not necessarily harassment. If you've been warned by the police, if you've been warned by someone to send them, it could become. But if it's just simple, a breakup in a relationship and an accused is trying to get back with the person and sends them 5 or 10 emails, it's not necessarily harassment. There's not necessarily fear either. Obviously, cases cross the line. There's no question. But does this case cross the line? Even if the complainant's credible, even if they're reliable, the documents go in. But on the other hand, the complainant could be testifying about things that are not documented. We're trying to challenge that, create a reasonable doubt. So are the elements made out is it cross the line, and is fear made out, reasonable fear? Well, you can always argue that an objective person wouldn't have fear. Okay, so in the context of a breakup relationship, there's a breakup, the accused sends 10 emails that are polite emails asking to get back together. The complainant asks not to email them again, sends them one more email. Do you mind if we get back together? Where's the fear? It has to cross the line at some point, and that type of thing is not necessarily criminal harassment, where it's just very polite emails. At some point, volumes of emails become fearful. It could. Depending on what is said in them, of course. Threatening conduct is always fearful, there's no question. And I'm not trying to minimize these cases. I've been involved in many cases where there's horrible harassment, we plead guilty, and I've been involved in other cases where it doesn't even make sense that we're going to trial because it's just a few innocuous emails. So that's my goal, to challenge that witness, to challenge the elements of the defense, to argue there's not fear, to have the client will potentially testify to say, look, I didn't follow this person, it didn't happen. If the client's, there's a WD test that's applied, if the client's credibility is on the line, if they testify, and if the judge believes the evidence of the accused that they didn't follow that person, they must acquit. Even if they are not left in a reasonable doubt, I should say, even if they don't believe the accused at step 2 of the WD test, if they're left in a reasonable doubt by it, they must acquit. And step 3 is, which is the most powerful step at all, let's say the judge completely rejects the evidence of the accused, doesn't believe him. Yes, you did that following twice or once, and you sent all those emails. I don't believe you. Well, there still could be a reasonable doubt. There might not be reasonable fear. The emails were innocuous, and the person just looked at them at the mall once. Is there reasonable fear beyond a reasonable doubt? Maybe, maybe not. And are the elements of the offense broken out? Is it repeated stalking? Is it repeated emails? Is it repeated conduct of following or watching them, at their house? So You can win these trials. I mean, obviously, I'm going to recommend to clients, there's overwhelming cases you can't win, but there's cases that are on the line, there's cases in the gray area, and there's overwhelmingly strong defense cases that shouldn't even go to trial. And hopefully the Crown chooses to withdraw those type of cases, but they don't always, the weak cases. So that's how you win these cases. You work hard, you prepare the client, you prepare to cross-examine the complainant and argue the case law that the case just does not meet the test, and there's a reasonable doubt either based on the case law or the facts of the case, and the case should be thrown out. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.